Start. The petitioner who joined government service as Patwari was served with a memorandum dated 4th April 1988 issued under Rule 16 of the Rajasthan Civil Services Classification, Control and Appeal Rules 1958, whereby an inquiry was proposed against the petitioner in respect of 4 charges levelled against him. The petitioner submitted a reply to the charge sheet in the month of September 88 and denied that charges by an order dated 15th November 88. The sub-divisional officer Byawar was appointed as inquiry officer. This, according to the petitioner, was done without application of mind to the reply filed by the petitioner. Evidence of the department as well as defense were recorded by the inquiry officer. The petitioner has, of course, alleged that statement of some witnesses were recorded expert without any justification. The petitioner submitted written arguments on inquiry. This request was turned down by the collector, Land Records, Ajmer. Wide letter dated 1 March 1990. The inquiry officer submitted a report, and on the basis of that report, that the collector Ajmer passed an order dated 14th 891 and imposed a penalty of dismissal from service on the petitioner. The petitioner has asserted that a copy of the inquiry report was not made available to him before passing of the order of punishment para. The petitioner has challenged the order of punishment on several grounds. He has asserted that the inquiry has not been held by a legally appointed inquiry officer. He was not given opportunity of defending himself, and above all, a copy of the inquiry report was not made available to the petitioner before passing of the order of punishment. He was not given any opportunity to make representation against the inquiry officer. He has stated that on 25th 791, collector of Ajmer had given him opportunity of personal hearing. During courses of hearing, he had brought to the notice of the collector the pronouncement of the Supreme Court in Union of India versus Ramjan Khan, and also of this court in Tej Karan Jain versus State of Rajasthan, to the effect that it is necessary to furnish a copy of inquiry report to the delinquent before an order of punishment can legally be passed. But both the decisions have been ignored by the collector Ajmer in passing the order of punishment para. This writ petition was admitted on 28/8/91, and having regard to the main contention raised on behalf of the petitioner that copy of inquiry report was not given to him before passing the order of punishment, notice was given to the learned additional government advocate para. I have heard the learned counsel for the petitioner and learned deputy government advocate. The main argument which has been advanced by the learned counsel for the petitioner is that the order of punishment passed against the petitioner is liable to be quashed because it has been issued in violation of the provision contained in Article 311 of the Constitution of India, Rule 16 of the Rajasthan Civil Services Classification, Control and Appeal, Rule 1958, as well as the principles of natural justice. Sri Samdaraya Learned Counsel for the petitioner has vehemently argued that under the scheme of Rule 16 as it stands, even after amendment made in the year 1983, it is obligatory for the disciplinary authority to give a copy of the inquiry report to the delinquent employee before an order of major punishment can be passed. He has placed reliance on the decision of the Supreme Court in Union of India versus Muhammad Ramzan Khan and Tej Karan Jain versus State of Rajasthan. Full stop.